should we legislate morality? In our society today, we frequently hear arguments about which issues should and should not be concerns of public policy. For example, there is considerable debate about whether and to what extent social issues like abortion and same-sex marriage, as opposed to economic and foreign policy issues, should be issues in our political life. It is sometimes said that moral issues are not for the law to regulate. We can't legislate morality. But I think it's closer to the truth to say that we can't help but regulate morality, since actions that are permitted by law come to be more easily accepted or at least tolerated in society. In this brief class today, I'd like to make 2 points, both of which are important: the power of law to support morality and the definite limits on that power. So, can we legislate morality? Well, let's begin with the simple observation that morality or virtue cannot, in a literal sense, be compelled. Morality has to be free, voluntary, chosen. It does not consist merely in certain actions, but rather in free choices based on habits or firm dispositions to act in a certain way. But the most thoughtful advocates of legal regulation of morality have never claimed to make people moral by law. According to them, good laws cannot and should not impose morality, but rather help to create or foster the conditions that facilitate the formation of good habits. Laws accomplish this goal in 2 different ways. First, by prohibiting certain acts, the law can make them more difficult, reduce their likelihood that people will do them easily, and prevent the formation of bad habits. Second, law also plays a role in the very formation of our ideas of what is moral and immoral. So let's begin with the first: law, morality, and habits. One simple effect of prohibiting particular actions by law is to reduce their frequency, especially by imposing costs on people who do them. These costs can be formal legal standards, such as prison time or fines, or informal punishments, such as the public embarrassment of legal convictions, or the simple fact of being involved in any legal proceedings at all. Even prohibition, for example, the classic example so often cited to prove that you can't legislate morality, reduced the net consumption of alcohol in American society. Pornography laws reduce consumption of pornography. Abortion laws reduce the number of abortions. Of course, there are many times when a law is not successful in preventing or punishing the actions it is meant to prohibit. The fact is that you can say that about virtually all laws, but who would say that laws dealing with murder or rape or theft ought to be repealed simply because they're not always successful? And it's also true that laws may have no effect if there's absolutely no efforts to defend or enforce them. But the problem in that case would be the failure to enforce, not with the law itself. The reason for the success of the law in reducing the instances of bad behavior is very simple. Take the example of pornography. There are at least 2 groups of people in society who will not be affected substantially by legal regulation. First, there are some people who are virtuous and don't need the law. Even without the law, they would not indulge in pornography. Second, there are others who are so committed to immorality that they will successfully evade any law prohibiting it, since there will always be a black market for items to which human nature as we know it is strongly inclined. Arguments that effective regulation of morality is impossible tend to focus on these kinds of citizens as if they were the only ones, and emphasize that legal regulation of morality affects them very minimally. But this approach ignores the existence of others, usually many more people, who are neither firmly committed nor firmly opposed to certain immoral acts. These include, among others, the people who sometimes indulge in something like pornography, but feel a sense of shame for doing so. And it includes people who know that pornography is wrong and are willing to say so, who really believe it, but who find themselves on some occasion giving in to the powerful impulses to indulge in it. These kinds of people, many people, stand to benefit from a law restricting pornography. They are prevented from indulging in vices because the law makes it harder for them to do so, and they are not so committed to these vices that they will make heroic efforts to evade the law. Now, why does it matter that the law can reduce the frequency of a certain kind of behavior? After all, someone might argue, if you don't do something just to avoid punishment, are you really a better person? The answer to this objection is that it's not just that there are fewer bad acts, it's that people are less likely to form bad habits by continually and frequently engaging in those acts. Habits, dispositions to act in a certain way with facility, easily, are formed by repeated actions. The more often we do something, the easier it is to do it. This is true on a physical level. So for example, if we swing a tennis racket and do it over and over the same way, it makes it easier for us to do it in the middle of a game. But it's also true on the moral level as well. If we make a continuous effort to control our tempers, even when provoked, eventually we'll do it with less strenuous effort. Perhaps we can think about habits as channels or grooves that we metaphorically cut in ourselves. The more we use and dig out and deepen these channels, the easier it becomes to do that action again, other things being equal, because of course circumstances will have an impact. In the case of pornography, for example, it's not just the habit of reading pornography itself that's at issue. It is more importantly what pornography tends to reinforce in us. The habit of reacting more easily and more strongly to sexual stimuli, and the habit of not exercising control over the desire for physical gratification. That habit influences not only our future reading of pornography, but the very way that men look at women in general, pornography generally being a male vice, and especially the tendency to view them not as people, but as objects for the gratification of sexual desire. Let's turn now to the second way that law can help support morality, its role in the formation of moral convictions. To understand this, it's important to pay attention to what may be called a sociology of moral convictions and beliefs. Moral ideals can and should be arrived at by a process and effort of human reason. That's ethics, a branch of philosophy. But human beings are not simply isolated and disembodied intellects who possess an innate knowledge of morality. They are social creatures who live in communities, and they are creatures born with the potential to act well, but this potential needs to be fostered and developed, and our social environment plays a role in this process. For reasons noted by great thinkers like Thomas Aquinas and Alexis de Tocqueville, most human beings are not capable of producing their own comprehensive ethical theories. They don't have the ability or the time to do so. So ask yourself, where do most people get their moral ideals from? For many people, it's their families and their churches. But where do families get their moral ideals from? Religion's an obvious and very important source for many individuals and families, but it isn't all-powerful. It's not the only factor. This is seen most clearly in the fact that oftentimes people of the same religion have different moral ideals with respect to the same aspect of life. To take an example from our own society, many of those in the United States who are American Catholics hold sharply opposed views of morality. Perhaps one way to formulate this point is to say that some American Catholics are more influenced by their Americanism than by their Catholicism. The influence of the culture in which they live outweighs the influence of their faith. But this suggests that in addition to family and faith, other communities of which we are a part influence our moral views. One of these is the political community. People's moral beliefs are typically influenced by the many human beings around them in the various human communities of which they're a part. Just as there's a physical environment, including the air that we breathe without thinking about it, so there's a moral environment, a moral ecology, from which we often absorb, as if by osmosis, the general opinions and attitudes of those around us. If the law permits actions, and especially if those actions become commonplace in society, it's much more difficult to maintain social ideals that are critical of those actions. Now, law is only one way in which society's general opinions are expressed. To take only one example, the media and the entertainment industry exercise enormous influence in a similar way. But the law is one way, and a particularly formal and authoritative way. It's society going on record as saying that some forms of human behavior are frowned upon. A powerful example from American history is civil rights legislation. Laws such as the Civil Rights Act of 1964 were intended to prohibit certain acts, racial discrimination in public accommodations, for example, and they achieved this to a significant extent. But it's arguable that the most important effect of the law was its educative effect. It was a solemn national statement reaffirming the principle of racial equality. And this law, in conjunction with other factors, has contributed to the profound change in racial relations in this country in the last generation or two. And who would say that the law was unnecessary or undesirable simply because there were other factors encouraging this change? Today, the very efforts of groups that favor or oppose certain laws to get them added or taken off the books is testimony to the importance of law, as in the case of the struggles in our country regarding abortion and same-sex marriage. Those struggles are partly about whether particular acts will be permitted, but it is, perhaps even more importantly, about shaping the attitudes of current and future generations toward these matters. So, laws, besides preventing or reducing the formation of bad habits, also play a key role in the formation of people's moral ideals. Law may not make people moral, but it can play a role in helping people to be moral. But now that I've made that point, let me turn to the other side, the limits on what law can do. If law can play a role in providing conditions that foster morality, we also have to be sensitive to the limits of law as well. First, we need to remember the point I made way back at the beginning of this talk. It's not possible for the law actually to legislate morality. Moral actions must be freely chosen, not merely compelled. But beyond that, there's also a need to be careful not to rely too much on law to promote morality. As one might expect, the greatest historical exponents of legal support for morality, such as Aristotle and Aquinas, were decidedly moderate moralists. To take one example, let's look at Thomas Aquinas' answer in his great work, the Summa Theologiae, to the question whether it belongs to the human law to repress all vices. His answer is no. Why? Well, Aquinas argues that what it is possible to impose on men through law is limited in two ways. First, laws are framed not for the very best people, but for average or ordinary people, for most people. But most people are not highly virtuous. So laws don't forbid all vices from which the virtuous abstain, but only the more grievous vices, he says, from which it is possible for the majority to abstain, and chiefly those that are to the hurt of others, without the prohibition of which human society could not be maintained. Thus, human law prohibits murder, theft, and such like. Aquinas also points out an important danger. If you try to impose on imperfect men precepts that they cannot bear, then, he says, the precepts are despised, and these men from contempt break out into evils worse still. Human law is framed for the many, and it should prohibit only what most people are capable of abstaining from, and what's especially important for maintaining society. Second, in addition to natural differences among men, there are also differences that arise from the particular features of a given political community. Law also must be in keeping with what is possible given the customs of the country. Now, if bad habits have deep roots in a culture, law is not likely to be able to uproot them. In fact, as Thomas notes, the precepts of such a law will be despised, and the ordinary citizens unable to take such regulation will break out into worse evils. An example of this might be the creation of a backlash that would make the law worse than it might have been otherwise. Better to aim lower, perhaps to restrict or limit certain vices successfully, rather than try unsuccessfully to obliterate them, and in the process make people despise the law. What this means is that there is a definite relation between a given country's general culture and which vices the country's law is capable of repressing. The attempt to prohibit vices that are deeply rooted in the community, that is, vices to which many citizens are deeply attached, is likely to be a failure. Moreover, the difficulty of accomplishing such a task will likely require greater harshness in the law. This itself is a cost to be concerned about, since 1, it may aggravate the resentment against the law. 2, it may augment the coercive power of government and the habit of accepting greater levels of coercive government action, which is always subject to potential abuse. And 3, undermine the kind of civic friendship on which a polity rests, the sense that citizens have that they are part of a community and not merely subject to it. Now, this does not mean that laws are incapable of regulating an activity simply because it occurs or even because it's widespread in society. How common a practice is will be only one factor in evaluating what the general moral standards of a community are. The fact that many people act in a certain way does not automatically mean that such actions are part of a community's moral principles. Laws can announce a community's moral standards while tolerating in practice, but not in principle, a fair amount of conduct that's inconsistent with it. For example, despite laws in the past restricting it, there has always been a good deal of sexual immorality in every society, such as fornication and adultery. But that does not mean that laws against them were senseless or useless. By announcing and giving prominence to society's moral ideals, they have supported families and churches in their efforts to maintain a higher level of sexual morality and made sexual immorality less common than it might otherwise have been. At the same time, given the powerful urges in that direction, attempts to rigorously enforce laws against sexual morality would likely have provoked a backlash. And so our society and others have typically limited what they try to achieve by reserving enforcement of such laws to very public or high-profile cases, tolerating considerable private sexual immorality that goes under the radar in society. So whenever a society considers legislating on some moral issue, it needs to make a careful prudential judgment about exactly how much is reasonable to prohibit and how vigorous the enforcement of the limits can be. And in this prudential judgment, it will have to weigh the importance of the moral limits, not just as a matter of personal morality, but as a matter of social well-being. How important is it to the common good? So, to take a simple example, adultery is a much greater evil than fornication, not just as a moral matter, but especially as a social matter, since it strikes at marriage and the family, which is the fundamental institution on which society rests. And in a given society, it might be best to deal with only the worst part of an evil rather than the whole thing, so that the law might consider tolerating a great deal of sexual explicitness while prohibiting only the worst forms of pornography. So what can we conclude from our discussion today? 2 things, I think, especially. Number 1, law really can play a role in supporting morality in our society. But 2, there will always be significant limits on the ability of law to promote morality. This moderate moralism, so characteristic of classical philosophy as represented by Aristotle and Aquinas, should be our guide to approaching questions of law and morality in our own society. We should not give up on the idea of promoting morality through the law, but we should also be careful not to have exaggerated expectations about exactly how much the law can accomplish.